Hey, this is LawsuitLegal, and today we want to talk about women's rights involving pregnancy and the workplace. There are three major acts that relate to worker pregnancy rights: the Pregnancy Discrimination Act, the Family and Medical Leave Act, and the Americans with Disability Act. On top of these national acts, there are also state-level based family and medical leave laws. The Pregnancy Discrimination Act was passed in 1978 and amended Title VII of the Civil Rights Act of 1964. Its purpose was to prohibit sex discrimination on the basis of pregnancy, as well as covering discrimination on the basis of pregnancy, childbirth, or related medical conditions. The PDA provides the protection for pregnant workers involving hiring, pregnancy and maternity leave, health insurance, and fringe benefits. The PDA also works to prevent discrimination based on a current pregnancy, past pregnancy, potential or intended pregnancy, and medical conditions related to pregnancy and childbirth. It should be noted that the PDA only applies to employers with 15 employees or more, and employers are exempt from providing medical coverage for elective abortions except in the case where there is a risk to the mother's life. However, they are required to provide disability and/or sick leave for women recovering from an abortion. There are lots of legal document resources available online to look more into the Pregnancy Discrimination Act. Title VII of the Civil Rights Act of 1964, Facts about Pregnancy Discrimination, Legal Rights for Pregnant Workers under Federal Law, Guide to Employment Law and Regulations by State, Enforcement Guidance on Pregnancy Discrimination and Related Issues, Recent EEOC Pregnancy Discrimination Litigation, and Employer Best Practices for Workers with Caregiving Responsibilities. The Family and Medical Leave Act was passed in 1993 as a federal law that requires employers to provide employees with job-protected and unpaid leave for qualified medical and family reasons, including personal or family illness, family military leave, adoption, and pregnancy. The FMLA was intended to balance the demands of the workplace with the needs of the families, according to the Department of Labor. To be eligible for coverage under the Family Medical and Leave Act, an employee must have worked for that employer for at least 12 months, have worked at least 1,250 hours during the 12-month period, and work at a location with at least 50 employees that must be within 75 miles of their workplace. Under the Family and Medical Leave Act, an employee is entitled to maternity leave that includes 12 work weeks unpaid leave in a 12-month period, and maternity leave includes the childbirth and care for the newborn, adoption foster care, and care for the newly placed child, care for an immediate family member with a serious health condition or their own serious health condition. Some online legal documents regarding the Family and Medical Leave Act include the Family and Medical Leave Act of 1993, the Family and Medical Leave Act FAQ, break time for nursing mothers under the FLSA, Family and Medical Leave Act fact sheets, and FAQ concerning the use of FMLA leave to care for an adult child. The Americans with Disabilities Act was enacted by the U.S. Congress in 1990 and provides protection for Americans with disabilities, similar to the Civil Rights Act of 1964, with protections against discrimination based on race, sex, religion, national origin, and other characteristics. Due to these protections, any impairments resulting from pregnancy may be considered a disability under the ADA, and your employer may be required to provide proper accommodations. Legal documents regarding the ADA include Titles I and V of the Americans with Disabilities Act, disability discrimination, the ADA, your employment rights as an individual with a disability, and best practices for providing reasonable accommodation. Frequently asked questions on the ADA and FMLA, Women and the ADA, and the PDA and ADA working together to protect pregnant workers. The Family and Medical Leave Act allows states the options to set their own standards when it comes to the family and medical leave laws, which could sometimes be more expensive than the federal law. For example, the federal FMLA only applies to employers with 50 or more employees within 75 miles. Some states have enacted their own FMLAs that have a lower threshold for employer coverage, including Maine with 15 or more employees for private employers and 25 or more for the city or town employers, Vermont with 10 or more employees for parental leave and 15 or more employees for family and medical leave, and Washington, D.C., which is 20 or more employees. Some states also expanded on the definition of what is considered family, including California, which includes domestic partners and their children, Connecticut, which includes a civil union partner and parent-in-law, and New Jersey, which includes a civil union partner and their children, parent-in-law, and step-parents. 4 states have also passed laws which require paid family and medical leave, and those states include California, New Jersey, Rhode Island, and New York. You can find many legal documents online regarding state-level family and medical leave laws, including state-by-state tables, paid family leave laws for California, New Jersey, and Rhode Island, state family medical leave laws that differ from the federal family, and a medical leave act. If your employer has been in violation of the Pregnancy Discrimination Act or the Family Medical Leave Act, you may be entitled to financial recovery, including back pay, front pay, reinstatement, compelled hiring or promotion, compensatory and punitive damages, as well as reimbursement for attorney and court fees. Make sure to find an employment lawyer who is going to best represent you in your case to best protect your rights to family and medical leave.